years, the amount of gun violence that has happened, I think we're reaching a tipping point where we're about to hit desensitization to gun violence.
We begin with breaking news in the deadly shooting at that 4th of July parade in Highland Park, Illinois.
Still assault-style weapons in the state.
The assault weapons ban passed both chambers at the tail end of the lame duck session. And
some Illinois gun owners wonder what will enforcement look like. Officials here with Illinois State Police say...
So when you say you won't comply, does that mean you won't register your gun with...
That is correct. I have no intention of registering anything.
Illinois gun restriction. In recent developments related to the Illinois rifle and mag ban, the Supreme Court has denied emergency relief in 2 cases seeking to stop the ban. However, there's another crucial case, federal firearms licenses of Illinois v. Pritzker, that could impact the upcoming registration deadline scheduled for January. The state of Illinois has implemented a statewide rifle and mag ban, allowing grandfathering for certain arms, parts, and mags if individuals go through the registration process. However, the compliance with this registration deadline has been significantly low, with only around 8,000 arms identified out of the millions present in the state. The key focus of this lawsuit is to obtain a preliminary injunction against the upcoming registration deadline. A preliminary injunction is a temporary halt on the enforcement of a law, and it requires establishing 4 main factors, with the likelihood of success on the merits being a primary consideration. This legal action seeks to challenge the constitutionality of the registration requirement and aims to provide relief to arm owners in Illinois who may face criminal convictions and liabilities for non-compliance. In rapid, while the Supreme Court hasn't granted relief in some cases, the federal firearms licenses of Illinois v. Pritzker lawsuit presents a significant legal challenge that could impact the enforcement of the registration deadline in the state. The outcome of this case may influence the broader landscape of gun regulations and individual rights in Illinois. Supreme Court upholds. The U.S. Supreme Court's recent decision to decline blocking Illinois' ban on assault-style rifles and large-capacity mags marks a significant development in the ongoing debate over arm control measures in the United States. The ban, enacted in response to a tragic mass slaying in Highland Park in 2022, has been a focal point of legal contention, reflecting the broader national conversation on the balance between individual arm rights and public safety. The Protect Illinois Communities Act, signed into law by Democratic Governor J.B. Pritzker in January, addresses the sale and distribution of specific high-powered semi-auto weapons, including AK-47 and AR-15 rifles, as well as mags with capacities exceeding certain limits. The legislation emerged as a response to a massacre at an Independence Day parade in Highland Park, where 7 people lost their lives and many others were injured.
We begin with breaking news in the deadly shooting at that 4th of July parade in Highland Park, Illinois.
Gun violence does not discriminate. It happens everywhere and all the time.
As the death toll continues to grow, at least 7 people killed, more than 30 wounded.
Years, the amount of gun violence that has happened, I think we're reaching a tipping point where we're about to hit desensitization to gun violence.
The ban aims to curb the accessibility of arms associated with high casualty rates in mass slayings. The recent Supreme Court decision signals the court's reluctance to intervene in state-level arm control measures, leaving the law in place while legal challenges unfold. The National Association for Armed Rights and Law Weapons and Supply, a firearms retailer, sought a preliminary injunction against the ban, arguing that it infringes upon Second Amendment rights. However, the court's unanimous decision indicates a hesitancy to disrupt state-level policies, especially in the absence of a clear constitutional violation. The legal battle surrounding the Illinois ban echoes a broader nationwide struggle to address armed violence while respecting constitutional rights. The Highland Park massacre served as a catalyst for renewed efforts to enact stricter arm control measures, reflecting concerns about the increasing frequency and severity of mass slayings. The decision to focus on assault-style rifles and large-capacity mags reflects a targeted approach to limit the potential lethality of arms often used in such incidents. However, the court's decision doesn't settle the broader question of how to strike the right balance between arms rights and public safety. The Second Amendment guarantees the right to bear arms, and any attempts to restrict that right face scrutiny through a constitutional lens. Armed rights advocates argue that such bans infringe on individual liberties, while proponents of stricter arm control measures stress the imperative to address the alarming trend of mass slayings and arm-related violence. The Supreme Court's role in this complex and contentious issue is pivotal, as its decisions shape the legal landscape and influence state-level policies. The court's reluctance to grant an injunction against the Illinois ban suggests an inclination to defer to state governments in crafting and implementing armed control measures. This approach aligns with the broader legal principle of federalism, emphasizing the authority of states to regulate matters within their borders. As legal challenges continue, the Supreme Court may face additional opportunities to weigh in on the constitutionality of specific armed control measures. The outcome of these cases will inevitably impact the ongoing national conversation about armed rights, public safety, and the role of government in addressing the complex issue of armed violence. The delicate balance between individual liberties and collective security remains at the forefront of this debate, and the Supreme Court's decisions will play a crucial role in shaping the future trajectory of armed control policies in the United States. Second Amendment challenge unsuccessful. The legal battle against the assault weapons ban in Illinois has become a focal point for armed rights advocates, particularly the National Association for Armed Rights, Robert Bevis, and his arms store Law, Weapons, and Supply. Their challenge is based on the belief that the ban infringes upon the Second Amendment, which protects the right to keep and bear arms. The case emerged in response to the tragic 2022 massacre at an Independence Day parade in Highland Park, prompting the state to enact the Protect Illinois Communities Act. The act, signed into law by Democratic Governor J.B. Pritzker in January, specifically targets the sale and distribution of high-powered semi-auto assault weapons and large-capacity mags. This includes rifles like the AK-47 and AR-15, as well as mags exceeding 10 rounds for long guns and 15 rounds for handguns. The law's intent is rooted in addressing the severity of gun violence, particularly in the aftermath of the Highland Park incident. The legal challenge reached the 7th U.S. Court of Appeals, where the court ruled against the challengers on November 3rd. The court justified its decision by stating that the bans were likely lawful, emphasizing that the Second Amendment primarily protects weapons intended for individual self-defense rather than military-grade weaponry. This distinction was crucial in their assessment of assault weapons and high-capacity mags. The ongoing legal battle challenges the deep divisions in the United States over armed control and Second Amendment rights. Armed rights advocates argue for the broad interpretation of the Second Amendment, asserting the individual's right to possess arms for self-defense. In contrast, proponents of stricter armed control measures, including bans on assault weapons, point to the need for addressing the unique risks posed by military-style firearms in civilian hands. The Supreme Court's refusal to block the assault weapons ban in Illinois signals a complex legal landscape where balancing public safety concerns with individual rights remains a contentious issue.
Still, assault weapons in the state.
The assault weapons ban passed both chambers at the tail end of the lame duck session. And
There's a lot of people that the Illinois State Police would have to go look for and give felonies to.
After it was debated and then passed in the House yesterday, it quickly made its way to the desk of Governor J.B. Pritzker.
Some Illinois gun owners wonder what will enforcement look like. Officials here with Illinois State Police say
the court's recent decisions, such as recognizing the right to carry a handgun in public for self-defense, underscored the ongoing evolution of armed rights jurisprudence. As the legal battle unfolds, it raises questions about the scope of the Second Amendment and the extent to which states can regulate firearms to address public safety concerns. Ultimately, the outcome of this case may have implications for armed control policies and the interpretation of constitutional rights in the United States. Supreme Court armed control. The recent decision by the U.S. Supreme Court to reject an emergency appeal to halt the implementation of a new armed control law in Illinois has stirred controversy and intensified the ongoing debate surrounding armed rights and regulations in the United States. The law in question, known as the Protect Illinois Communities Act, was enacted in response to a tragic mass slaying at a 2022 parade in a Chicago suburb where 7 people lost their lives. The law, set to take effect on January 1, 2024, targets high-powered semi-auto weapons and large-capacity mags. It imposes a ban on the possession, manufacture, or sale of specific semi-auto rifles and high-capacity mags, including popular models like the AR-15. Additionally, the legislation places restrictions on the capacity of arms, allowing rifles to hold a maximum of 10 rounds and handguns 15 rounds. The act also mandates the registration of these arms and accessories with the Illinois State Police, a process that began in October 1st. The legal battle surrounding the law reached the U.S. Supreme Court after the Chicago-based 7th U.S. Circuit Court of Appeals ruled against the law's challengers. The 7th Court, in a decision on November 3rd, found the ban lawful, arguing that assault weapons and high-capacity mags are more akin to military-grade weaponry than arms used for individual self-defense. This decision echoed the broader national discourse on the role and regulation of arms in American society. The Supreme Court's rejection of the emergency appeal was notable for its lack of public commentary or dissenting opinions. The court's conservative majority, which has historically expanded arm rights, chose not to intervene in this instance. The decision aligns with the court's general reluctance to grant emergency relief and may be seen as a signal regarding their stance on state-level arm control measures. The legal challenges against the Illinois law were brought forth by the National Association for Arm Rights, firearms retailer Robert Bevis, and his store Law Weapons and Supply. The plaintiffs contended that the law violated the Second Amendment of the U.S. Constitution, which protects the right to keep and bear arms. However, the 7th Circuit, as well as the Illinois Supreme Court, upheld the law's constitutionality. This case is part of a broader legal landscape where arm rights activists are challenging state-level arm control measures across the country. While the Supreme Court has expanded arm rights in landmark rulings since 2008, the current legal battles highlight the ongoing tension between individual arm rights and public safety concerns. The court's refusal to block the Illinois law underscores the complexity of balancing these competing interests and leaves the fate of similar arm control measures in other states uncertain.
But that it starts with the ban in effect in Illinois.
But some Illinois gun owners are skeptical just how proactive police will be when it comes to enforcing this.
So when you say you won't comply, does that mean you won't register your gun with?
That is correct. I have no intention of registering anything.
Numbers show less than 1% of legal gun owners have done this.
The decision is expected to have a significant impact on the enforcement of the law, allowing Illinois to proceed with the implementation of its assault weapons and large-capacity mag ban. As the nation grapples with the ongoing challenge of addressing gun violence and crafting effective arm control measures, this case serves as a focal point in the broader debate over the constitutional limits of arm regulations. Supreme Court upholds Illinois. The U.S. Supreme Court's recent decision to decline an emergency appeal in 2 cases seeking to block an assault-styled rifle and large-capacity mag ban in Illinois has stirred controversy. The ban, enacted after a mass slaying in Highland Park in 2022, prohibits the sale and distribution of certain high-powered semi-auto weapons and mags. The law, known as the Protect Illinois Communities Act, was signed into effect in January by Democratic Governor J.B. Pritzker. The case involves the National Association for Arms Rights, Robert Bevis, the owner of Law Weapons and Supply, and others who challenged the ban, arguing that it violates the Second Amendment. The Supreme Court's decision not to block the law leaves it in effect while an appeal is pending. The National Association for Arms Rights, Bevis, and others are seeking to overturn a lower court's decision denying their request for a preliminary injunction against the ban. The legal battle revolves around the interpretation of the Second Amendment and how it applies to restrictions on specific arms. The 7th U.S. Circuit Court of Appeals previously ruled against the challengers, stating that the bans were likely lawful, emphasizing that the Second Amendment pertains to weapons for individual self-defense and not military-grade weaponry. The plaintiffs argue that the bans are overly restrictive, infringing on law-abiding citizens' Second Amendment right. They contend that assault weapons and high-capacity mags are commonly used for self-defense and that the bans go beyond what is necessary for public safety. The Protect Illinois Communities Act bans the sale and possession of various semi-auto rifles, handguns, and mags. Firearms and accessories that were legally owned before the law's enactment must be registered with the Illinois State Police. The registration process began in October 1st, and the law is set to take full effect on January 1st. One critical aspect of the legal challenge is the claim that the law violates due process by failing to provide adequate notice to arm owners about the new requirements. The plaintiffs argue that residents weren't sufficiently informed of the changes, hindering their ability to comply with the registration process. Additionally, the challenges point to recent Supreme Court decisions such as the 2019 New York State Rifle and Pistol Association case to support their argument. They contend that the bans should be subject to strict scrutiny analysis, emphasizing the importance of core Second Amendment rights and historical considerations. The lawsuit, officially titled Federal Firearms Licenses of Illinois v. Pritzker, involves notable entities such as the National Association for Arm Rights, Law, Weapons, and Supply, Arm Owners of America, and legal representation from Michel and Associates. The legal team has experience challenging gun laws, particularly in California, and aims to address the broader implications of the ban on semi-auto weapons.
To the newsroom, California cannot ban gun owners from having detachable magazines.
Having high-capacity magazines. The judge says there's no American tradition of limiting ammunition capacity.
100 bullets that can be fired from that weapon.
It is the bill Ferguson has been trying to get passed since 2016. That year, a 19-year-old used a high-capacity rifle.
They sometimes feel outgunned by assault weapons with large capacity magazines. That we passed in 1994 with bipartisan support in Congress and the support of law enforcement.
While the Supreme Court's decision not to block the ban at this stage doesn't determine the final outcome, it sets the stage for continued legal battles over the constitutionality of such restrictions. The case raises questions about the balance between public safety and individual arm rights, exploring the limits and scope of Second Amendment protections in the context of evolving arm control measures. Legal battle over firearms. Michel and Associates has filed challenging similar bans in other states, particularly California, comes into play. They argue that the vagueness in defining what constitutes an assault weapon part creates confusion and hinders arm owners' ability to comply with the registration process. This nuanced approach is strategic given the firm's extensive experience in fighting against similar regulations. Another key argument focuses on the due process concerns raised by the lack of proper notice. The motion asserts that the state of Illinois failed to provide adequate notice to arm owners about the new requirements, violating their right to due process. This approach challenges not only the bans on specific arms, but also the restrictions on components and parts related to arm assembly. The legal team delves into the language of the legislation, highlighting the vague and unclear definitions of what constitutes an assault weapon part. The argument suggests that the lack of clarity in defining certain components makes it challenging for arm owners to understand which parts are subject to registration. Specific examples, such as the ambiguity surrounding terms like pistol grip and collapsible stocks, are cited to illustrate the confusion arising from poorly defined language. The motion ultimately seeks a preliminary injunction against the enforcement of the registration deadline, emphasizing the urgency of the matter. It contends that the combination of vague definitions, lack of proper notice, and potential due process violations warrants immediate action to protect the rights of arm owners in Illinois. This legal strategy reflects Michel and Associates' deep understanding of Second Amendment challenges and their experience in navigating similar legal battles, particularly in states with stringent arm control measures. The outcome of this case may have broader implications for arm rights as it addresses not only the bans on specific firearms, but also the intricacies of registration processes and the importance of clear and constitutionally sound language in firearm-related legislation. Legal battle arm rights. The legal battle over Illinois' ban on assault-style rifles and high-capacity mags is a pivotal moment in the ongoing national discourse on arm rights. The case, brought by the National Association for Arm Rights, Robert Beavis, and his store Law, Weapons, and Supply, challenges the constitutionality of the ban, asserting that it infringes on the Second Amendment. The genesis of the controversy lies in the tragic events of 2022 when a mass slaying occurred during an Independence Day parade in Highland Park, claiming 7 lives and injuring dozens. In response to this tragedy, the state of Illinois enacted the Protect Illinois Communities Act in January. The law, signed by Democratic Governor J.B. Pritzker, imposes a ban on the sale, distribution, and possession of several types of high-powered semi-auto weapons, including rifles like AK-47 and AR-15, along with mags holding more than 10 rounds for long guns and 15 rounds for handguns.
Tonight, President Biden announcing his first ever federal office of gun violence prevention.
For that 10 years we had it done, the number of mass shootings actually went down.
That law was unconstitutional, but the ruling will not take effect immediately.
But after Republicans let the law expire in 2004, and those weapons were allowed to be sold again, even law enforcement officials have told me and told other champions of this legislation.
This raises questions about the fairness and constitutionality of the law, as individuals may inadvertently run afoul of the regulations due to unclear definitions and lack of guidance. The broader implications of this case extend beyond Illinois, as several other states have enacted similar bans on semi-auto weapons. At least 8 other states, along with the District of Columbia, have some form of prohibition on these firearms. The legal challenges to these bans, citing the Supreme Court's expanded interpretation of the Second Amendment, are making their way through federal courts. The outcome of this case will likely influence the ongoing debate over armed rights in the United States. With the Supreme Court's conservative majority, which has historically taken an expansive view of the Second Amendment, the legal landscape for gun regulations is fluid and subject to change. As the legal proceedings unfold, the case serves as a microcosm of the broader tensions surrounding armed control, individual rights, and public safety. While the tragic events that led to the enactment of these laws cannot be ignored, the legal challenge highlights the delicate balance between addressing public safety concerns and upholding individual constitutional rights. In decision, the lawsuit against Illinois' assault-style rifle and high-capacity mag ban is a significant chapter in the ongoing saga of armed rights in America. The legal arguments put forth by the plaintiffs underscore the complexities and challenges surrounding the interpretation and application of the Second Amendment, with potential ramifications for similar laws across the nation. The court's decision in this case will undoubtedly shape the trajectory of future legal battles over gun regulations. National debate on arm control. The national debate on armed control in the United States remains a contentious and deeply polarized issue, touching upon fundamental questions of constitutional rights, public safety, and individual freedoms. The conversation is often fueled by high-profile incidents of gun violence, mass slayings, and efforts to balance the Second Amendment with measures aimed at curbing arm-related tragedies. One of the central points of contention lies in interpreting the Second Amendment of the U.S. Constitution, which states, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The interpretation of this amendment has been a subject of intense legal, political, and societal debate. Proponents of expansive armed rights argue that the Second Amendment guarantees an individual's right to own firearms for self-defense and other lawful purposes, asserting that any attempts to restrict this right infringe upon personal freedoms. On the opposing side, advocates for stricter armed control measures emphasize the need to address the alarming rates of gun violence and mass slayings across the country. They argue that regulations on firearm ownership, background checks, and limitations on high-capacity mags and assault weapons are necessary steps to enhance public safety and prevent tragedies. These advocates often point to other countries with stringent armed control laws and lower rates of gun violence as potential models for the U.S.
In March of last year, the Washington legislature passed a law banning the sale of ammo magazines that hold more than 10 rounds.
I know this has been a hobby horse of mine for a long time. Got it done once, like AK-47s and AR-15s. And in the 10 years it was law.
But California Attorney General Rob Bonta argues they aren't necessary for private self-defense.
Also ban assault weapons and high-capacity magazines in this country.
The armed control conversation is not confined to legislative chambers, but extends to public discourse, media coverage, and advocacy efforts by various interest groups. Organizations such as Moms Demand Action and Every Town for Gun Safety have emerged as influential voices pushing for increased gun regulations. Conversely, groups like the National Rifle Association, NRA, staunchly defend armed rights and resist what they perceive as encroachments on the Second Amendment. The issue is further complicated by the patchwork of state-level gun laws, creating disparities in regulations across the country. Some states have implemented strict armed control measures, while others have opted for more permissive policies, reflecting the diverse attitudes toward firearms in different regions. As the national debate on arm control unfolds, it remains a dynamic and evolving discourse shaped by ongoing events, legal challenges, and shifting political landscapes. Finding common ground amid deeply entrenched positions poses a formidable challenge, but the urgency to address the impact of gun violence on American communities ensures that the conversation will persist, with potential legislative changes continuing to be a focal point in the foreseeable future. That's going to do it for this video, guys. See you next time, and bye for now.